Thank you for joining us today. My name is Stephanie Anderson, and I am the Industry Operations Manager at the National Apartment Association. If you are new to our series, we welcome you. If you have been with us on this journey, we do welcome you back and thank you for your continued support. In an effort to provide our membership timely operational guidance amid COVID-19, we are producing daily updates in the form of micro webinars. Each day, we will focus on a different topic relevant to the apartment industry. At this time, I would like to direct your attention to the screen. Please take a moment to review our disclaimer. Today's webinar is sponsored by NAA's Click and Comply program. NAA is offering a sneak peek of its newest compliance solution, NAA Click and Comply, by releasing a rent relief request form for property management companies to utilize across their portfolio. This form will easily document and track requests for residents who are suffering financially during COVID-19. This will include special arrangements and payment plans that have been made and agreed upon by the property and its residents. This form is powered by Leonardo 24/7, is free of charge for 6 months, and will allow property management companies to pull reports with detail on each property or an overview across the entire portfolio. The rent relief request form launches on April 1st. If you are interested in this form, we encourage you to contact Nicholas Tovar at the email address on your screen. Today, I am honored to introduce Billy Cannon, Principal at Offit Kerman Attorneys at Law. Billy will be sharing legal guidance on property management to include rent collection, late fees, filings, and payment plans. Billy, welcome.
Thank you, Stephanie, and thank you everyone for tuning in and for joining up and trying to figure out what the best practices are for all of us in what is a very tumultuous and uncertain time. I will be brief and direct in trying to provide some real-world practical advice and recommendations with regard to management at your property. We will start with rent collection and then move through relatively short order a couple of other scenarios that are occurring currently at your properties, I am sure. The basic premise that we'll operate from with regard to rent collection is that the lease remains in place. And I say that knowing full well that you will be getting requests and demands probably in some instances for waivers or deferments or payment plans. But from a very basic premise, you are continuing to provide housing, and to the extent they are able, you should expect residents to continue to pay your rent. So from a contract perspective, at least at present, things are not different than they were a few months ago, although as we know, reality being what it is, things are quite different. It is important, despite this basic premise and approach, that you make sure that you check and become aware of any emergency orders or legislation in your particular jurisdiction that might impact your ability to collect rent. For example, there may be laws that have been enacted that put a local moratorium on evictions or require landlords to not charge late fees during a time period when a state of emergency has been declared. Obviously, those laws would impact how you would seek to collect rent from residents and whether you would be charging late fees for residents who fail to pay you timely during the state of emergency. Additionally, on a safety note, you should be encouraging your residents to pay online. If online is not an option, then create a Dropbox if you don't have one at the property, or a similar repository for your residents to use. And then if there's any employee who's on site handling any money orders, checks, what have you, those employees should of course be using gloves and then should wash their hands immediately after handling the payment. Okay, so to get into the deferments and rent and payment plan requests a little bit, which we'll explore even in more detail later. Despite this approach, right, that the lease remains in place, it has to remain in place, and the communication that it remains in place needs to be made with an empathetic eye towards an awareness that so many of your residents will be financially impacted by the coronavirus emergency, as so many people will be nationwide. One of the things I'm recommending to all of my clients right now, and to be clear, I'm recording this on March 31st, so things may change. Pause before taking any action to assist impacted residents. And I don't mean that in a way that suggests that you won't take action to assist impacted residents, but I do mean that in a way that allows you to have the time and space that you need to try to wrap your head around a little bit the extent and scope of this coronavirus emergency, how rapidly it's changing, and to try to think a little bit forward to the extent that that's possible about what you might offer to your residents in a way that might end up being meaningful both to them and palatable to you. It's my belief that waiting until April 10th or April 15th will certainly help you as a property manager to have a much clearer picture of what is going on at your property in terms of residents who will be and who will not be able to pay rent, and what that may mean for your property, both at a local and at a national level. One of the things that a lot of landlords are doing, and as I mentioned earlier, some jurisdictions are actually mandating this, but one of the things a lot of other landlords are doing of their own volition is waiving late fees that are incurred by residents who are experiencing an economic hardship based upon this coronavirus emergency. NAA has created a notice of temporary waiver of late fees, which you can access on NAA's coronavirus guidance page. It's important, as always, to consult with local counsel before using any form, obviously, but in particular here, I think, as we're in a little bit of an emergency situation, the form isn't approved for use everywhere. But if you are looking to do something for your residents and waiving late fees is something that you are inclined to do, the NAA form is a great place to take a look and to get a sense of what might be palatable or possible for you to implement at your property. And as I mentioned, it's important that some jurisdictions have already enacted emergency legislation, which may impact a landlord's ability to charge late fees. That's in addition to the CARES Act, which we'll talk about in some detail in a few minutes. So a lot of property managers and landlords are also talking about offering payment plans to residents. I think I like where this comes from. In talking to my clients, I'm hearing a lot of them say that they really want to do something to help residents who have been impacted negatively by the coronavirus, and so it comes from a great place. And I'm very happy to represent so many people who are so benevolent in such a difficult time. But I have counseled them, as I'm counseling you, that offering of any kind of payment plan has to be done with care and significant thought and planning in advance of any communication about it. That's part of the reason why I'm counseling my clients to pause for a few days, maybe up to a week or more, to really think about what makes the most sense, and also to see how both the virus itself on a public health scale as well as on an economic scale continues to impact the nation. I know that you have already likely received resident requests for payment plans, for deferrals, for waivers. And I think that residents who are reaching out to you proactively are to be thanked for doing that, because it makes your job a lot easier to have a good understanding of what's happening at your property and what steps you may need to take. You may, after internally discussing it and considering it, decide to offer payment plans at your property. The one very, very strong cautionary word I will give you on this is to be mindful of the Fair Housing Act. The offers that you may make to residents, either in response to their requests or by your own affirmative outreach, cannot discriminate against any protected class. And it's sometimes difficult to make those offers in a way that doesn't discriminate, even if you're coming from a place where you're trying to do something to help people, as so many of the landlords that I've talked with recently are. Communications with residents. It's really, really important, of course, to communicate with your residents during this extremely difficult time. Make sure that residents are aware that they should be letting you know if they cannot pay rent due to the coronavirus. It does not make sense to ask for any documentation associated with a resident's claim that they cannot pay due to the coronavirus until you check with your local council and make sure that this kind of an inquiry is permitted by local law. I will again raise the flag of the Fair Housing Act. Although it's not a direct impact necessarily on this kind of an inquiry, you should be thinking, if you're a property manager that has Fair Housing Act training, that an inquiry or request for documentation seems an awful lot like a reasonable accommodation request. And I think that the similarity is telling, if not exact. The other thing about communications with residents is to be what I will say frequent and timely and consistent in terms of how you communicate with them. Given the fact that the coronavirus emergency is changing so rapidly in so many different areas of the country, I think it makes sense to try to get into a pattern of communication with your residents, to communicate with them on a regular basis, to let them know about what the CDC, as well as your local public health authorities, are saying about the precautions that they should take individually as tenants, and about the precautions that you are taking at a property level in order to do what you can to ensure their health and safety. More communication in this regard is, generally speaking, better, as long as that communication is consistent. The one thing I'll say is that it's difficult to be consistent right now because things are changing. So your communication should take that into account, and should state somewhere that you will continue to be in touch as the management company or the property manager or the landlord with your residents because things are changing, and you will try to keep them as up to date as possible. I'll note, though, that if you decide to do this, please take the obligation seriously. In a multifamily setting, residents will rely on their managers in a way that they won't rely on many other folks during a time like this, in part because in many areas of the country right now, people are under a stay-at-home order. And so the multifamily building has become the place where so many residents are currently staying at home. I'm going to talk for a few minutes now about the CARES Act, which was passed and signed on Friday, March the 27th. It is extremely important that you come up to speed quickly on the CARES Act if you are a property manager or landlord. NAA has a statement on the coronavirus guidance page, which provides an excellent primer and excellent introduction to how this law is going to impact landlords on a national basis. Let me tell you, it is significant. There's a lot to unpack here. I'm going to try to go through it as systematically as possible right now. The first step is to find out whether or not your property qualifies as what the law defines as a covered property. And it will do so because of its status as an affordable program, and there's a long list of affordable programs that make a property a covered property, or because the property has what the law defines as a federally backed mortgage. A word on that. The law defines federally backed mortgage in an extremely broad way. So it's very important that you take a look at the specific language in the law and make sure that you are in touch with folks who are able to tell you in a definitive way whether or not the mortgage for the property that you manage is federally backed or not. The second step is that if your property is a covered property, Get in touch with local counsel ASAP to find out what can and what cannot be done. And I'm going to tell you a little bit about what cannot be done. Covered properties are not permitted to file for eviction for non-payment of rent or charge fees or issue notices for 120 days. So that is until late July. July 26th or 27th would be the first date on which you would be permitted to file for eviction for non-payment of rent or to charge any fees or to issue any sort of notice that you might be able to issue under your lease or your local law. However, covered properties, covered multifamily properties, should be able to obtain forbearance from mortgage payments for up to 90 days if they experience economic hardship due to the coronavirus emergency. It's extraordinarily likely that most, if not all, multifamily properties are going to experience economic hardship due to the coronavirus. And it becomes even more likely for a covered property that is not going to be able to file for eviction until late July, that an economic hardship will be suffered. As a result, one of the things that I'm talking to a great number of my clients about is applying for a forbearance for the months of April, May, and June, or May, June, and July, depending upon when it becomes clear at a property level that an economic hardship has been incurred. But it's really, really important just to go back that you go through the analysis to find out whether you're a covered property, because it impacts your ability to file for evictions. And it also should impact, as a multifamily property, your ability to obtain forbearance from mortgage payments for up to 90 days, which should help to significantly soften the blow from a potential really, really large delinquency. If you do think that you're not a covered property and you want to initiate an eviction action, obviously you're going to have to make sure that the courts in whatever jurisdiction where your property is located are accepting filings and are open. So many of them right now are either shut down or are in some sort of a de minimis operating mode that does not permit eviction filings. And to do that, the strong recommendation, is that you contact local counsel. It's clear under the CARES Act that there are multiple levels of inquiry and analysis before anyone at a property should be assured that it's eligible to file for eviction. I've also noted, I think earlier, and we'll note again here, you've got restrictions on charging late fees, other fees or penalties, and as well as issuing any notices to vacate at the property. So contacting local counsel is really, really important. A bunch of clients have asked me what it means for cases that are, I'll say, already in the pipeline, meaning, that were filed sometime in March before the states of emergency were declared on such a broad scale and before courts started to close down. It's unclear, obviously, what this will mean for cases that were filed prior to the CARES Act, putting a moratorium on evictions. But I think in many, many jurisdictions, it's going to be likely that courts are doing two things. Number one, operating with an eye toward providing relief consistent with the prohibition on evictions in the CARES Act for residents of covered properties, regardless of the timing of the filing. And I think also that courts are, in a lot of jurisdictions, likely going to be in a position where they're going to be asked to interpret new legislation. I don't think that we are done as a nation in terms of what legislation we will see that impacts the ability to file evictions, to go through the eviction process, to collect rents, to do the things that we do in managing properties. I think that locally and also perhaps nationally that there may be more to come. So also circling back to one of the ideas we mentioned earlier with regard to communications for residents, one of the things that you can think about in terms of the communications that you push out to your residents is to try and provide them with a list of local and national resources that might be available to them. Salvation Army, Red Cross, other national organizations, as well as, local, usually faith-based organizations or other similarly situated organizations that may help them to pay rent. And then the other thing I think that I've seen a lot is the need to push out regular updates and reminders regarding what's expected in terms of behavior at the property relative to the coronavirus. One thing that I'm seeing a lot of with children being home from school is that there's obviously a great burden on parents to try to supervise those children. And I think that burden is very, very heightened when children are put in a multifamily setting, and instead of having space and place to play, perhaps they are more cooped up than they're used to being. But it's important, I think, that social distancing, as well as other recommendations from both the national and local government, be communicated and posted as frequently as possible to your residents. One thing that some properties are experiencing, obviously, are lease renewals. So it's important to identify residents whose terms will end soon and to begin to think about how to handle renewals. There are, I think, a number of options at your disposal that are, probably some are consistent with what you would normally do, but some probably are necessitated by the coronavirus emergency that we're experiencing. You could allow leases to convert to month. Sometimes that could happen at the same rental rate for the duration of, perhaps the CARES Act prohibition on evictions. You could offer shorter term renewal options. Again, that kind of a renewal option could be keyed to the 120-day prohibition on evictions, keeping residents in place for that amount of time only. There are, I think, price gouging laws in many states that could impact whether or not a rent increase that you would seek to implement would be legal in this environment. I know that especially if you're seeking to increase rent to a tenant who is becoming a month-to-month renter, sometimes the premium that you might charge on a month-to-month rent is an amount that will bring you into the scope of violating a price gouging law. So I really urge you to be careful with regard to implementing rent increases generally, and especially in the case of some sort of a month-to-month premium or any other premium that you might ordinarily charge. It's not, given that we've got an emergency situation in our country and so many of our states, it's not a good time to be implementing those fees without considering the implications. And then in terms of lease renewals, I'll also raise the Fair Housing Act flag again. As you consider what your offers you're making to residents, just remember that the surest way to make sure you're complying with the Fair Housing Act is to treat everyone the same. So rather than making different offers to different residents and perhaps putting yourself in a position where you have unwittingly walked into an accusation of discrimination, make sure that you are offering the same terms to everyone. All right, well, thank you guys for joining me for this micro webinar today. It's my feeling that in this uncertain and tumultuous time, that as landlords, you occupy a unique space and you have a corresponding opportunity to be leaders in helping your residents and helping your communities through this emergency. I think that one of the best ways to do that is to spend some time thinking through the difficult scenarios in advance and using that time, which I've suggested could become really important for you as you plan the next 7 to 10 days to make some hard decisions. and think about how you're going to handle what's coming down the pike, and to communicate consistently and effectively with your residents about that. I really appreciate you joining. Please continue to look for updates and guidance for NAA. And please feel free to contact me if I can be of any assistance. Thank you very much.
Billy, thank you so much for sharing your expert knowledge with our members today. As Billy mentioned before, we are happy to help with any questions, concerns, and comments that you have. In addition to the information for Billy to contact him, we've also included on the slide an email address, cv19questions@naahq.org. We would love to hear any questions, concerns, or comments you have that are related to COVID-19. In addition, we did release yesterday a brand new best practice on NAA's operational guidance amid coronavirus page, and it is geared specifically towards a lot of the areas that Billy has covered today. It's titled Rent Collections. So please check that out. We look forward to seeing everyone back tomorrow for another great topic on our micro webinar series. And again, we thank Billy for all of his time and knowledge today. Thank you so much and have a wonderful day.